If state justice system, a court system, does not integrate AI at all in their workflow, so judges still work even with just a pen and a paper, it doesn't mean that AI is not there. That's wrong. There's nowhere to hide.
Pietro Ortolani, professor of law and dispute resolution expert. Today he talks about why big tech platforms already act like massive private courts, how the EU's Digital Services Act opens real outside review, and what it means as AI enters the courtroom.
All sorts of non-legal factors that affect judicial decision-making. For example, are you tired? Are you hungry? Are you overworked? Our idea in the Netherlands, in continental Europe, is that the judge should be the mouthpiece of the law. So those factors shouldn't tilt a decision towards you get probation, you don't get probation. What is the argument for leaving the judge alone with the problem without that type of help? And the real challenge is, how do you integrate the technology in this workflow in a way that actually empowers human judicial decision-making instead of stifling it?
What can we learn from esports?
There's a whole lot of new sports disputes in esports that we have not seen in traditional sports. I think there's never been a better, more interesting period to be a lawyer.
Let's say our court system is adapting AI and automatic dispute resolution at a certain point. So the easy cases get disputed by a computer.
My personal view is that
this episode is powered by Zeno. Zeno's AI navigates law like a human legal professional, grounded in authoritative sources, backed by traceable citations. Visit zeno.law and make deep thinking your competitive edge.
Pietro, welcome. Nice to have you on the show.
Thank you so much.
Thank you for making the time.
Of course.
I want to start this conversation with large online platforms, like large social media websites.
Yeah.
What can we learn from those platforms regarding online dispute resolution?
Right, that's a great question. And it's something that might feel surprising for the listeners, for the audience, in the sense that if you think of a large platform, e-commerce platform, social media platform, and by the way, the boundary doesn't exist anymore, right? So Instagram is also an e-commerce platform, of course. You don't think of dispute resolution. You think of digital services, you think of products, you think of services, you think of influencers, that type of stuff. But in fact, every very large online platform is also a dispute resolution platform.
And a large
one, a very large one. In fact, it's bigger than any small claims court in the world. To understand this, it's maybe helpful to take a step back and think of the internet of the early 90s, right? When it was still a very experimental thing, a very niche thing. And think of eBay when they started. Small company, and their mission was to create an international online marketplace. The biggest challenge they had was that people were not used to buying things online. You're very young, so maybe you don't remember it.
I don't remember.
Right.
For me, it's normal.
For you, it's actually weird to go into a physical shop, perhaps.
It's easier to order online.
Of course.
Why should I bike somewhere for 10 minutes?
But I can tell you, in the 90s, in the early 90s, people thought that's weird and risky in a way. Because, I'm in this marketplace, but I don't know the seller. I don't trust them. I don't know where they're located. Who's going to help me if I have a problem? That was the biggest challenge that eBay initially had to overcome.
People were afraid.
People were afraid, absolutely. And they realized very early on, if we need to build consumer trust on the marketplace, we need to resolve disputes. People need to know, if I have a problem, the platform will help me. And that's why you trust platforms these days. You don't even question that, but you know you're not alone. You know, if you have a problem, you buy something on Amazon Marketplace, Amazon will be there for you. You're getting your money back one way or another, right? This is nothing new. I come from Tuscany. In the Middle Ages, Tuscany was a huge place of commerce, international commerce, in fact. And you can still see it if you go to the market square in any Middle Ages Tuscan city. There's a corner where there used to be, and you can still see it sometimes, a desk for the arbitrator. So there was somebody on the marketplace to resolve disputes. Why? Because otherwise people wouldn't trade with each other. They wouldn't think it was safe enough to buy silk from somebody coming from the Netherlands Who's going to measure it if there's a dispute? Well, there was somebody to do it. So if you need trust on the marketplace, you need dispute resolution. So eBay very early on built online dispute resolution. Basically, they built their own courts, informally speaking. And in fact, they hired people coming from public service to do that for them. The most famous person to do that was Colin Rule in the 90s. And now you see the same thing happening with social media, right? Social media platforms take an astounding amount of decisions about what you can or cannot do on the platform.
Well, we saw 251 million statements of reasons over 20 days.
Yes.
That's crazy.
Right. So now we have an insight into the scale of the phenomenon thanks to the Digital Services Act database on transparency. I think that's where you got it from. So in a year, it's about 51 billion decisions. And those might be decisions to remove content, to suspend an account, to terminate accounts. On top of those, you need to add all of those decisions that you don't find them on the database, where somebody complained about something and the platform said, no, this is fine. We're not doing anything about it. Those are invisible, but probably you need to double those numbers realistically, right? All of those cases are essentially a dispute. It's somebody wanting something reinstated or remonetized, or somebody else wanted it kicked out of the platform.
And it's so normal. It became so normal for us to fix these kind of disputes.
It would be crazy to think that for any of those disputes, you would need to go to the judge. Of course, eventually you do need for some very high profile cases to go to the judge.
Let's imagine that they need to do 251 million cases in 20 days.
So, people that say these are fundamental rights and a judge should always decide, it's impossible. The scale is unprecedented, right? So you need this type of online dispute resolution. Of course, for some cases, you also need the judge.
Yeah, the more serious cases maybe.
Of course.
Yeah.
Cases where there's an economic interest. Think of, for example, very serious violation of copyright, of trademarks, or cases with a big public impact. Think of the decision to allow Donald Trump back on social media, right? That is a decision that affects us all in the world.
But what can our justice system learn from these online systems? Because they take so many decisions in such a short time. Can we learn something from them?
I think we can learn something from them and they should learn something from us.
Yeah, so it's both ways.
Two-way dialogue, indeed. The first thing that we can learn is that it is possible to create a system of dispute resolution that is low value but high volume. And this is something that traditionally we as lawyers have thought was impossible. Why? Because when you're a lawyer, you only have a hammer traditionally and you see everything as a nail. So when you think of dispute resolution, you studied law, right?
I studied law.
So what did you think about when you thought about dispute resolution?
Well, that it takes a lot of time, that it takes a lot of effort, that you need a lawyer, that you need a judge, that you need different parties.
So you didn't even say that out loud, but you were thinking of a court.
I was thinking also of a court. Yeah,
Right.
I was not thinking about, say, a robot judge in my phone.
Right.
And we all have phones, and I think we all have a robot judge in our pockets
Absolutely.
these days.
And for one case that ends up in court, there's thousands of them that end up in a platform.
Yeah.
So what, at a very descriptive level, I'm not making a value judgment here, but the first thing you can learn is that there are very different ways to create and structure a dispute resolution system that allows you to have dispute resolution at that scale. That is, in my opinion, you could think that's very worrisome because it comes with all sorts of questions about due process, fairness, transparency, and that's all true. But there's also a positive side of the story, that is to say, well, now that we have digital dispute resolution, you can ensure some kind of dispute resolution for a huge volume of dispute that we didn't think was processable before. That's made possible by platforms, as you said, but more broadly, we could think, what can AI do to allow that type of justice at scale?
Yeah, because let's take one step back. You just talked about the internet of the 90s. Of course, now since 2-3 years, AI is a very, very big, powerful world also in the world of justice. Is AI speeding up this whole process? of this dispute resolution on such a scale?
Well, I think on platforms, it is definitely the key component. And here we're taking a very broad picture of what AI is. But if you go back to the database that you mentioned already, you see how many of those decisions were fully automated. And for many platforms, it's the almost totality of them.
Yeah.
So, of course, that type of scale wouldn't be processable without some kind of automation. It's debatable whether we can call it AI or not. And I'm not going to go into the debate what is AI, what counts as AI or not.
We're 3 hours further.
Yeah, indeed. And I think that you interviewed people with a lot more knowledge than me on the topic. But, of course, you need automation in the mix, right? And on that private sphere, I think that automation and AI are really doing a lot to speed up the process, to enable it in the first place. And I think actually they could do a lot more and a lot better. Because you might think, Meta and Twitter and all of the very large social media platforms, they use state-of-the-art AI to moderate content. That's not necessarily true. We know, thanks to many different experiences, the Oversight Board, the Digital Services Act, we can go more in detail into this if you like. We know that sometimes the AI that platforms use to do this job is very rudimentary. Just to give you an example, there was a case on Instagram of somebody posting a picture of a naked female breast to show how to detect breast cancer. That is allowed under the Instagram guidelines and the terms of service between the user and the platform because, it is a naked breast. That's generally not allowed on Instagram.
But it's for a different reason.
Well, it's for a very good reason. And we now know, thanks to a case that ended up at the Oversight Board, that the entire automated content moderation procedure of Instagram was able to detect a female breast, but absolutely unable to understand why it was posted. And you see it again and again, for example, with religious imagery where there's, a painting with somebody naked, but it is a work of art and a religious imagery, and it gets flagged as if it were almost porn, right? That shows how, AI could even do more because with the latest generation of AI, you can do much more in terms of contextual awareness.
Yeah, but you mentioned the Oversight Board.
Yeah.
I want to hear more about the Oversight Board in a second. But when I talk to judges, when I talk to lawyers, they're a bit afraid that we get like an Amazonification or a Googleization of our justice system.
Right.
Because of all these systems, everything is going so fast. Is that a real danger?
I mean, it is. But I think there's also a lot of opportunity in there. And there's no way you can hide from it. So the very first fallacy of not only judges and in general of people with a law degree is to think if I don't integrate it in my workflow, I'm safe. I'm in the good old world and AI will not touch me. That's wrong. There's nowhere to hide. Just to give you a practical example, if a state justice system, a court system, does not integrate AI at all in their workflow, so judges still work even with just a pen and a paper, it doesn't mean that AI is not there. The parties will use it. The parties will bring it in. And if a judge has no awareness of what they're doing with AI, they will not be able to assess, for example, okay, this party is telling me that AI demonstrates that there's a very high likelihood that this piece of evidence is forged. Can I trust that or not? You see, there's nowhere to hide. The algorithm will be brought in the courthouse by somebody, very often by the disputing parties that want to win the case.
But that's already happening. The
It's
algorithm is already
happening.
inside of the courtroom.
Everywhere. The parties have an incentive to apply statistics, let's say, to prove a point of fact or law. I would also say that the concern is founded in as much as you would expect a judge to process that volume of disputes that a platform is doing. But that's not what we want. I don't think anybody would want that. I think that the type of platform decision-making is not bound and should not be substituted by judges. Judges are there, as you said, to review meaningful cases, difficult cases, controversial cases, cases with a social impact.
A bit like the same as the Oversight Board.
Yes, indeed. That is particularly interesting because it is an experiment made by Meta to basically build their own Supreme Court and actually import into the platform a logic that is the logic of a common law Supreme Court.
Because what is the Oversight Board?
So the Oversight Board is a non-judicial, of course, review body that has been created by Meta. Why? Well, at some point, Meta realized that some of the decisions they were making had a very huge impact in terms of fundamental rights. Because let's face it, when you need to moderate content at scale, sometimes you need to make very tricky decisions on what users can or cannot say on the platform. And that is something that not only requires drawing the boundaries of freedom of speech, but also balancing freedom of speech against competing fundamental rights.
There's always a balance with fundamental rights.
It is.
There's always a balance between what weight heavier and what is like.
Indeed.
Which road do we take?
Indeed. And typically, traditionally, this is done by a judge.
Yeah.
But now it needs to be done at scale, and it's done by platforms very often. So the idea behind the Oversight Board, and it's kind of a unique experiment, very interesting experiment, is, okay, the company doesn't want to be alone making these very tricky judgments. And so they will create an external body that's very generously funded and funding that cannot be pulled by the company to enable a group of very reputable people, very often lawyers, but not only lawyers. In the Oversight Board, there's, for example, an ex-Prime Minister of Denmark.
High-profile people.
Very high-profile people.
Experts in their field.
Indeed. To select a very small number of cases where Meta has made a decision and review them. And what the board has done from the very beginning is review those decisions against human rights law to say, is this compliant with our understanding of human rights law, which is not what a state would be bound by. It's a new life of human rights law in this transnational digital space. The interesting thing is that the Oversight Board was created by Meta voluntarily, essentially, through a complex structure with Delaware Trust, limited liability company, and individual contracts with the single members of the board, the judges, if you want to call them like that. But now, in Europe, we have a mechanism of out-of-court dispute settlement for content moderation cases that's actually disciplined, regulated by the law, by Article 21 of the Digital Services Act, and that enables any dispute resolution body in Europe to get certified and actually to perform this role of external review. So in a way, the board has been so successful that
now we have laws who take this board as an example.
Yeah,
and normally it's the other way around.
I think so. Indeed.
Normally Europe is coming with a very strict regulation, and then the companies need to adapt. And now Europe is adapting their regulation to this, maybe indirect, to this successful experiment.
Yeah, or at least they are opening up a market for dispute resolution. And this is something, I don't know if you have law students that listen to the podcast, but if you do, I would encourage every law student to look into this, because this is an entire new market. Every one of those 51 billion decisions per year is subject to review. And the business model behind it is very interesting because the users don't pay for it. The users get to choose to bring the disputes before any of these certified bodies under Article 21. And the costs of the procedure, which could be 100, 400, 800 euros, is paid by the platforms. The platforms must pay for the costs. So it means as a student, if you set up a body, you obtain the certification and you attract 1,000 cases per year, which is not difficult. All of them have more than 1,000 cases per year. You have a very interesting system, a very interesting business model.
We will cut this out and do it first ourselves before we will air this.
I mean, the beautiful thing is I think there's space for a lot of people, so you don't need to gatekeep it because there's 51 billion decisions and the market is huge. The possible difference in models and ideas of how to arrange it is huge. But the coolest thing for a young lawyer is you get to build your own procedure and give users rights and redress and getting paid for it. When people say, oh, this is the end of lawyers, maybe it's the end of the hourly billing model, but there's so much cool stuff you can do with it you were never able to do before. So I think it's very exciting, actually.
But how can we copy the situation of the Oversight Board to our court system that we have? Let's say our court system is adapting AI and automatic dispute resolution at a certain point. So the easy cases get disputed by a computer.
Right.
And then we should have like an Oversight Board who is still able to have a look at those cases, right?
So if I understand correctly, what you're positing is this idea of a judge as a sort of quality control human that comes in to review the outputs of the machine.
Yeah, because I think if you look at Meta, they're already so far in this process of automatic dispute resolution. I mean, we now have a robot judge in our phone. Maybe in the future, we will have a robot judge in our court system, in our system in the Netherlands or in other countries.
I think that's a very interesting idea, also troubling idea from a certain point of view. And my personal view is that there's a huge potential there. The technology can do a lot, and it would be foolish to ignore it. But at the same time, it's important to acknowledge that one size does not fit all. So you couldn't take that model that's made for mostly, almost meaningless disputes, a huge volume, but not very delicate disputes, and try to apply it and import it into a court system that we have created to deal with very important, meaningful, impacting disputes. Right?
Yeah, because also here in the Netherlands, we have a lot of problems with piling up cases.
Right.
There's not enough time.
Right. So what can you do? I think a very interesting experiment, which is done by the Dutch judiciary, but it doesn't require you to transform the judge into a content moderator, which you should never do, is voorrecht. I don't know if you know about
we
it.
interviewed the owner or the one who came up with this idea.
Right. So that's a great idea. And it is judges actually that came up with a question, how can we use LLMs in that specific case, large language models, to put case law in the hands of normal people and empower them to help themselves, which is very different from what a judge would traditionally do. But it's hugely helpful, I think, because in many, many cases, the citizen can actually find a solution on their own terms if just they understand the law, they understand where they stand, and they understand what they can do. The interesting about voorrecht is that in those cases where the information is not sufficient, then a judge will step in, and it will not just be, a case reviewer and a very repetitive, quick kind of content moderation, almost like assembly line model. It actually will be an in-person meeting with empathy, with all of the guarantees and all of the psychology of a courtroom. So you can combine the two.
But with a human.
Right. That's
an important difference.
It's a huge important difference. And I want to push back against this idea that if you have AI somewhere in the court system, in the public justice system, you necessarily are transforming judges into this very, bureaucratic, fast-paced reviewers of AI output.
That's not necessary.
No, it's a new world, AI. It's very new, it's very powerful, and it's up to us to find a way to integrate it responsibly in a way that actually empowers the judge to do their human work and add their human value in a better way. Let me give you another example. Now, the question you asked me already implied that the only way to integrate AI in courts is to get one output, present it to the judge and say, well, change a couple of commas here and there. And if you want, sign it. And so, we have a human review, token review, and we go on. You could think of very different ways of using AI. For example, what about a large language model trained on case law of the Dutch and European courts generate two concept judgments, one in favor of the claimant, one in favor of the respondent, or maybe 10 of them to show, look how many flavors you have here. So as a judge, you don't have blind spots. You know that there are many different ways to get to the same result or to different results. And as a judge, you are completely free to use one of them, combine them, or use none of them. In a way, if this is a way to debias the judge, to make sure that the judge doesn't have tunnel vision, that they see the entire complexity of the case, that actually heightens the human input of the judge. And if these models work well, we could get to the point where the question is not, is it ethical to use it, but is there an ethical argument to say, let's prohibit them, let's not use them at all, if they can help, right?
It's very interesting because I was interviewing a judge a few weeks ago about AI and about using AI in the court system. And she told me that she also thinks that AI can be a mirror for judges.
Yeah.
And that AI can show them certain patterns. And she referred to research which was done in Israel. And the research showed that after lunch, judges were like easier in their decision than before lunch, because then they were hungry and they were like, I need to go to lunch. And then AI could show those kind of patterns.
I think it really hitting the nail on the head with this one. And this is not just in Israel. There's empirical evidence from all over the world. There's all sorts of non-legal factors that affect judicial decision making. For example, are you tired? Are you hungry? Are you overworked? And so on. Now, our idea in the Netherlands, in continental Europe, theoretically, is that the judge should be the mouthpiece of the law. So those factors shouldn't tilt a decision towards you get probation, you don't get probation. For good reason, for very good reasons, I think. If that is the case, then if you can use technology to help a judge debias themselves, to help the judge decide, understand, oh, actually, I thought I was always doing the same, but I see a pattern here. I'm starting to maybe needing a break. What is the argument for for leaving the judge alone with the problem without that type of help? I don't think there's a very strong argument for just closing the door. The real problem is that once you open the door, the question is, how do you integrate it? And at that point, I think that you cannot ever look at the technology in isolation, because the technology becomes part of a human workflow. And there's going to be some kind of man-machine interaction. There's going to be a so-called socio-technical system. And the real challenge is, how do you integrate the technology in this workflow in a way that actually empowers human judicial decision-making instead of stifling it? And by the way, without being excessively dependent on private providers. That's a huge problem, right?
That's very important, because then you give away a lot of your control.
Right.
To private parties.
And we see it, justice for now, it's kind of a niche because it's a fairly small volume of public service, but we see it in education.
It's becoming bigger.
Healthcare, right? What if you get to the point where a school or a hospital or a courthouse doesn't work anymore if somebody from California pulls the plug? That is a real concern, much more, I think, than the crazy robot judge that will send everybody to prison.
Do you think we will get a robot judge at a certain point?
I think we do have a robot judge for small cases that never end up in court. And this is the 99.9% of disputes in society.
Which is a lot.
Which is the majority, if you stop looking at reality with the law school, traditional law school. Here in Nijmegen, we do much more than that.
But we will talk about
it. Let's say very traditional law school, you would think, if it doesn't go to court, it's not a dispute. Of course, that's not true. That's just, you don't see it as a lawyer because it never ends up in court. For those ones, we already have different flavors of robot judge. For the 1% or less than 1% that ends up in court, we do have AI one way or another already in the mix, if anything, because parties use it, lawyers use it. We know that sometimes individual judges use it.
Well, also individual clients.
Individual clients
they come to a judge and they say, hey, I prepared my own legal documents.
Have
I
you
did
seen
it
the
with
video
AI.
from the New York Supreme Court?
Yeah, and
the
she
judge
turned
was very-
crazy. She was so afraid.
But I think she was upset, not about the fact that this self-represented, for listeners that don't know, there was a self-represented litigant, so without a lawyer, that ended up at the New York Supreme Court, which despite the name is a court of first instance, so a rechtbank of New York State. And he tried to plead the case with an AI-generated video of a lawyer presenting the case. And the judge stopped it. And
She was angry.
She was very angry. She said, never again, I don't want to see this. I think the main reason for this almost knee-jerk reaction was that she had not been informed.
Oh, it was a surprise for her.
It was a surprise, and maybe one of the elements, I don't know, from what she said was that this person was actually trying to push AI as a business, and then that was kind of a show of what his AI product could do.
I think his business did very well after this video because the video went viral.
But what does this experience show you? It shows you that the judge cannot be left alone. There should be protocols, there should be rules, there should be
Education.
guidelines and education about what is this technology, what can it be used for, what should it not be used for. And even our case of the ChatGPT judge, Kantonrechter here in Nijmegen, right?
Yeah.
That is an example of a judge that's been left alone with the technology. The solution is not to ban the technology. The solution is to tell every judge, you need tools to understand what it is, and you need rules and practical skills to deploy it in a responsible way.
Yeah, the solution is also not to bash the judge.
Absolutely not.
Because he's experimenting with it. He's trying something. I mean, he's and then there was a whole article, I think, in the Financial Times of the Netherlands where a lot of people were like, yeah, this is not possible and should not use AI, etc. I mean, then you also stall this kind of innovation and experimentation for judges.
Absolutely. I mean, I think that in that case, he made mistakes or she made mistakes, I don't know. And some of my colleagues have written very convincingly on what went wrong in that specific case. I want to mention Pauline Erste, who's my colleague here in Nijmegen, Anna van Duin from Amsterdam. They wrote very beautiful articles to say, well, in that case, for example, there were some fundamental principles of Dutch civil procedure that were violated. But the solution is not to say, well, then let's throw away the baby with the bathwater.
Don't use it.
Don't use it at all. The solution is, well, that was an interesting experiment. It wasn't done properly, partially because you use ChatGPT without understanding what it is and what it can do or cannot do. So you need that education.
Don't leave the judge
tools.
alone.
Don't leave a single judge alone, right? It should be an institutional movement on how to allow or limit the use of LLMs in that context.
Let's go back to dispute resolutions from big social media platforms. A friend of mine is running a very successful company. And they posted a video on Instagram, I think 2 years ago, that went viral. And I think within 3 months, they had 500,000 followers. And now they're at, say, 1 million followers. Now they're setting up this business in all cities in the world. And they're starting Instagram pages in all of those cities.
Yeah.
They started, I think, in London. And within 2 months, they had around 40,000 followers. And then out of nowhere, their profile was deleted, was gone. And he put a message on LinkedIn at a certain point, like, hey, I already tried to contact Meta 20 times. Nobody is responding. Nobody is helping me. And our account is gone. And now our business in that city is also imploded. How do you make sure that these kind of decisions stay transparent and that you still have the possibility to know what happened here?
Right. That's an excellent question. And I think there's transparency, but there's also a problem of really fairness of what happens within the content moderation pipeline. And that is, in a nutshell, a perfect example of why the EU took action with the Digital Services Act. What is this regulation? Act is just, marketing. It's just a regulation. It is an attempt from the EU to inject certain guarantees, especially procedural guarantees, into this content moderation pipeline, which up until now has been a bit of a black box. So, your account gets demonetized or canceled.
Yeah.
You know why. You cannot call or email anybody. You're in the hands of this company. If you're lucky, you're in the hands of the Oversight Board, but for very, very limited amount of cases. Now, what the DSA tried to do was first to inject some guarantees within the system. So, for example, now you get a statement of reason, and you can ask for an internal review of that decision that cannot be entirely automated. So already now, with the Digital Services Act, your friend would have some kind of redress within the platform. But next to it, very interestingly, there's also this decision of the EU lawmaker to say a judge cannot review them all. Maybe in your friend's example, it would make sense to go to the judge because the money justifies it, right? But if you're starting, if you're, just a student with a startup idea, you might not be able to afford it. You need affordable out-of-court dispute settlement. And that is where ODS, Article 21 of the DSA, kicks in. So this idea that your friend would be able to select any of the certified dispute settlement bodies in Europe and ask them for an external review of that decision. And they would not pay for it. The platform would pay for it. That is a huge new market. And when it comes back to the RoboJudge example, that is the best testing grounds. Because if you want to embed AI into the Dutch judicial system, well, you have the AI Act, it's a high-risk system, you have constitutional law, you have human rights law, you have, of course, civil procedure, criminal procedure, all of those fields of law might limit your ability to do so for very good reasons, of course. In this world of Article 21, out-of-court dispute settlement under the Digital Services Act, yeah, you need a human in the loop, but you can use AI to a certain extent. How? Well, there's 50 shades of AI here, and as a company getting into the dispute resolution, the digital dispute resolution business, it's up to you to figure out how do you want to shape your man-machine interaction. Now, I think for a young law graduate, what's cooler than that? To build your own procedure and experiment with AI in that sense and give redress to people like your friend, for example.
So I have a sponsor for the show, and the sponsor is called Zeno. And Zeno is an AI platform for legal professionals with direct integration of current legislation and case law. And as part of that collaboration, they always have the chance to ask a question for my guest. And the question that I would like to ask you is as follows, and I think it's nice in the story you just told. What would you advise judges and arbitrators on maintaining meaningful human control as AI systems begin to assist or even shape parts of their decision-making process? So it's not a question for like the whole court system, but more for judges individual.
Right. The first point to get to responsible deployment is literacy. I would say don't use anything that you don't understand, at least in very broad lines, how it works and why it works. An LLM is not your magical friend inside of your computer that knows everything.
A lot of people think.
Well, because in a way, it's trained to react like that. It gives you the illusion that you're speaking to a machine that knows everything. And sure, knows a lot, it can do a lot.
Every time you ask a question, great question, Pietro.
Absolutely.
Great question, Hidde.
And by the way, there's all sorts of new psychological and even psychiatric problems coming from addiction to ChatGPT and other LLMs. So people that speak to these systems for 12 hours a day and they realize I'm a genius because ChatGPT always tells me that I ask the best questions and I have the best insights and so on. So literacy on the technology, but I would say also, paradoxically, literacy on the law, right? For example, if you're an arbitrator seated in a EU member state or one of your parties is in the EU, and if you're a judge in a EU member state, the Artificial Intelligence Act of the EU limits your possibility to use AI for decision-making and might, in some cases, even lead to a violation of the law for the simple fact that you use them without adhering to those guarantees that the AI Act requires for so-called high-risk systems. This is a regulation that is, of course, hot for us as AI people that love to talk about the technology, to think critically about it and so on. But of course, there are judges and arbitrators that might not even exactly know what it entails. And it's very dangerous to get into this type of experimentation without a baseline literacy of the technology and also the law governing that technology. In Europe, we have quite a lot at the moment already.
We have a lot of laws in Europe. If we talk about laws and we talk about dispute resolution, How do we make sure that the rules, for example, in Europe, but also outside of Europe, are uniform? That we know that all these systems work in the same way, and that everyone has the same kind of transparency and have the same kind of rights, whatever you're in Europe or in America or in Russia or in China. I don't know. I mean, those countries are maybe different, but you want to make sure that all those platforms were very international, that you know that you have the same kind of guardrails if you use these kind of systems.
Well, that's a great point and a great dream. My brutal answer would be you don't, to a certain extent, because those guarantees that I mentioned before with your example of your friend having this company being deplatformed, those guarantees would not apply if your friend was in Florida instead of in the Netherlands, right? Now, that doesn't mean that you cannot do anything. The first driver, maybe, of the EU to do legislation, so much legislation, some people say too much legislation on this field, is to trigger the so-called Brussels effect. And in some fields, this has worked. What does it mean? What is the Brussels effect?
Like privacy law.
Right. Privacy law is a perfect example. The idea is the EU is the forerunner of regulation. They set up rules. Those rules are quite demanding compared to the rest of the world. The companies need to comply with them because otherwise they face liability and they face, of course, huge also fines from public enforcers. They need to also be cost effective and efficient. And for that reason, they will end up taking the EU standard, which is the most demanding one, and applying them all over the world. So if this works, that's great because it leads to that type of harmonization without binding directly the platforms outside of the EU, but basically giving them an incentive to adhere to those standards internationally. The alternative, of course, is, and unfortunately these days we are forgetting that it even exists, but there is international law. And we should not forget about it. For example, the Council of Europe has the Framework Convention on Artificial Intelligence, which partially replicates the AI Act model, but it's open for ratification also from states that are not parts of the Council of Europe. So worldwide, potentially. That would be, of course, extremely beneficial in terms of harmonizing the regime, right? Also avoiding regulatory arbitrage, making sure there is a transnational bottom line. But of course, it's a very time-consuming and difficult process. I have been lucky enough to participate in some sessions of the United Nations Commission on International Trade Law Working Group on digital arbitration, let's say. I saw how difficult it is to get to a solution. And sometimes when you get to the solution, it's smaller than you would have dreamed when you were writing an article or a blog post or recording a podcast on the topic. Still, we should try, definitely. And another obstacle in that sense is that, in fact, the perception of AI around the world is very different. There are some legal systems and some countries around the world where the general feeling probably is, yes, AI is here. It's already having a huge impact on me, and I kind of trust it. I'm okay with it. And there are other legal systems and other countries, other cultures where we think AI is coming. It's not here yet. When it comes, it's going to be a science fiction movie. I hate it. We need to prohibit it. If you put these two cultures together in a room and you say, well, come up with rules that you're both happy with, of course, many things will be shaved off because one of the two parties don't.
It's not only inside of country. I mean, it's not only a difference between countries. It's also a difference between the sectors in a country. It's
and generations.
And generations.
Yeah.
If we look at, for example, lawyers of say 60, they have a very different view on AI than lawyers of 25 or 30.
Why do you think is that?
The same as the question you just asked me about eBay. I mean, I've grown up with ordering stuff online. So for me, I trust it. I trust the technology.
That's true. But just to make a counterpoint, if there was a convincing argument that AI would allow big law firms to bill more hours, do you think that
they would like it?
They would love it.
Yeah. And now they are afraid. They're afraid that it will take away hours.
Realistically, or maybe more radically, it will force lawyers to rethink the hourly billing system. Now, for those of you listening who are young, studying law, or new graduates, if the hourly billing system goes away, that's great for you.
They will find new business models.
Yes, and it's not. It's
I mean,
never
you just
been,
gave away one.
I just gave away. That's how generous I am. But seriously, the hourly billing system is not designed in the interest of young lawyers. So unless you're a partner at a very big firm, and that type of business goes away, I wouldn't worry. It's not a problem for you. I also wouldn't worry if we see that some clients of very large law firms, big law firms, are kind of less happy with purchasing legal services. I look at it from the dispute resolution perspective, but I think this applies also in other sectors. There's a fallacy here. And the fallacy is thinking the clients that currently are purchasing legal services in the Netherlands, for example, are the market. If they go away, lawyers have nothing left to do. That's not true. For every single one of those persons, legal persons many times, that can afford legal services in the Netherlands, there's probably 100 people that currently cannot afford that. If you can give those 100 people access to justice, you can find another business model as a lawyer, and probably at the end of your life, you can be much happier with your social impact, right?
Let's go back to dispute resolutions and have a look at esports.
Yeah.
It's a very interesting market. Esports, it's a very international market. It's all over the world. People are online. There are no borders. And they have some interesting dispute resolution systems, which we maybe can learn from.
Absolutely.
The same as with social media, where we can learn from. We can also learn from esports. What can we learn from esports?
So sports in general is a very interesting market for dispute resolution. Why? Because it needs to be fast. Of course, if you have a dispute concerning an athlete, a club, or even a competition, you cannot wait months before you know who won the Olympics, right? So that is traditionally an argument why sports disputes have always gone to arbitration. Now, for esports, it's particularly fascinating because you have some types of esports disputes which you would never have in traditional sports. For example, the game of football is not copyrighted. If you and I get bored with this conversation and we say, do you want to go play football outside? We can get a ball and play. It's legal. Esports are video games, and the whole sport, the game, is of course subject to IP law, to intellectual property law. So there's all sorts of licensing and IP disputes there concerning really the possibility to use the game to organize a tournament that you would never have if you and I say, well, next Saturday we meet at the field and we do a football tournament with our friends. So there's a whole lot of new sports disputes in esports that we have not seen in traditional sports. At the same time, it's a growing industry, but it's a very young industry. And the traditional sports arbitration, the most traditional venue for that is the Court of Arbitration for Sports in Lausanne. It's really quite expensive. It's too expensive for,
There's a high barrier.
Indeed, a young athlete, I call them athletes, gamers, and that
they will never go there.
They will never be able to afford it. Once again, this is great for young lawyers. Why don't you come up with a affordable, fair, digital arbitration system for esports? People out there are already trying to do that.
Are you a law teacher or a business teacher?
Well, I'm a law teacher, but I want to avoid this type of doomsday behavior and mindset of, law is something that is
from
old,
the past.
Something for the past, will be swept away. Traditional law firm models might be swept away, but I think for a young lawyer, for a young law student, that opens up an entire new field of new opportunities. You need to be very creative about it, but who, if not young people, right?
But if we look at esports, for example, if there is a dispute about an award, there is a two-expert panel, a legal and a technical person. The award goes inside of an evidence locker, and then within 7 days, there is a decision.
That's one of the models I was talking about, right? It is very fast. It is actually a lot of expertise in there because you can really get people that understand the esport, and there's not so many, especially if people also need to be able to conduct an arbitration. The pool becomes very small, and it really delivers justice in a way that is probably more accurate than what you would do in a traditional setting. So I think if you have that niche, if you love esports and you love law, that's one example where you can really come up with your own practice here.
And we can also learn from these systems
Absolutely.
for our court system, for the more serious cases
Absolutely.
that we have.
I go back to Forecht because in the Netherlands, it's probably the most clear example of judges that have said, okay, what can we learn? Can we think outside of the box and provide services as judges which are not the traditional judgment?
Let's finish this interview with AI in education.
Yeah.
There are some people in the Netherlands who say we need to ban AI. We need to ban AI from universities. We need to ban AI from law schools. I don't have the feeling you're at that side of this discussion.
No, I mean, I'm a pragmatist. So I think AI is part of the professional future of the people that currently are studying law. So if I, as a teacher, am to equip them for that future, I need actually them to use AI to tell me what they did with it and to be very critical about it.
And transparent.
And transparent about it. But if you're writing an essay, tell me how you used AI. Tell me if you used it for language purposes. Tell me if you used it to double check that your reasoning made sense. Tell me if you used it to come up with ideas that then you explore themselves. Or tell me, or maybe I'll say it myself, if you just copy pasted the output and put it in the essay. That's not good, but the idea to ban AI to prevent that from happening is actually counterproductive, in my opinion, because it leads to a situation where you actually leave them alone with the technology instead of...
Then you have the same problem as with the judges.
Absolutely. So I already mentioned Anna van Down. She wrote great stuff about this, how to integrate them, how to integrate these tools into education. It's not easy, and let me add something. It's not easy for us in a publicly funded university to get access to the best tools because they're very expensive and they're not part of our traditional toolkit. But there's nowhere to hide. We shouldn't hide from it. We should be very confident of our ability to integrate them in education so that the lawyers that we create for 10 years from now will be able to use it responsibly and also creatively to find these new ways of being a lawyer. Lawyers will exist, but in a different way.
And
probably.
the judges.
Judges will exist. Arbitrators will exist.
It's great if they walk out of this university and they already have a certain amount of knowledge about using this kind of technology in their work.
They need it.
And they need it because it's going to be everywhere. It's already everywhere, and it's going to be everywhere in, say, 2-3 years. And
Absolutely.
5 years or 10 years, it's going to be bigger and bigger and bigger.
Absolutely.
What would be your advice to... sometimes I give class about AI, and I teach students about how to use AI, for example, in production process, but also in law.
Yeah.
And those students ask me questions like, will my job disappear? I'm afraid that when I'm done with my study, I'm now in, say, year 1, year 2, I'm done in 3-4 years, then my job will not be there anymore. What would be your advice to, say, young lawyers or students who are now at the beginning or at the end of their study regarding AI in the future of their work?
So, again, the fallacy is to think that if you go to law school, your job in 5 years will be in the morning, wearing a suit, getting a briefcase, getting in a big skyscraper in a very small neighborhood of Amsterdam, because that's the only place where it happens in the Netherlands at the moment, and say, at 10 a.m. I have a meeting with Mr. Schmidt. I'd better be prepared because he's going to pay me 500 euros per hour for what I'm doing. That's not your job. You're a law student. That's not your job. Your job is to provide, in a meaningful way, legal human value in reality, in society. That job will never disappear one way or another. But you need to be creative about how you bring that value into reality, right? I gave you already a couple of examples. I would be very happy if in 5 years somebody stops me at a conference and say, oh, I listened to the podcast and now that's my business.
I have a company.
I have a company. Well, fantastic. Good for you. You've been very creative.
But you need to be creative.
Absolutely. You do need to be creative, but that's another fallacy, I think. the idea is, okay, not everybody can be creative. What about the people that used to just get a job and be employed somewhere? Well, first of all, it's not like jobs will end tomorrow, right? There will be still plenty of those. But to be honest, if you, at the beginning of your working year, I don't know what's the beginning of yours. For me, it's always September. That's when I think, oh, a new year is starting, right?
For me, it's the whole year.
Sorry?
For me, it's the whole year.
It's a whole year, right? So you look at your work year ahead and you think, I will do the same things I did last year. I know perfectly well how to do them. There's nothing new on my plate. There's nothing challenging on my plate. Are you happy? I don't think so. I think that's very depressing. So if that goes away, if you think in 5 years we'll have even better tools, how can we use them for better dispute resolution? That's what I do personally. That's fantastic. That's not your job ending. That's your job being much, much more interesting than it is today. I think there's never been a better, more interesting period to be a lawyer, to be honest. So I want the students to come away from this conversation with this core message. It's very cool to be a lawyer these days.
Thank you.
Of course. Thank you.
Thank you for listening to Legal AI Lab. Many thanks to my guest, Professor Pietro Ortolani. Follow and subscribe in your podcast app, leave a review, and share this episode. More conversations are coming with global leaders in AI law, justice, and policy. I'm Hidde Bruinsma. See you next time.
This episode is powered by Zeno. Zeno's AI navigates law like a human legal professional, grounded in authoritative sources, backed by traceable citations. Visit zeno.law and make deep thinking your competitive edge.